Good afternoon, ladies and gentlemen. Welcome to this IT governance webinar. This is Alan Calder. We appear to have had some unexpected connectivity problems, for which I apologize. We're not sure at this point why, but there we are. Anyway, thank you for having been patient. As I said, I'm Alan Calder. For those of you who've been patient and stayed here, we're going to be talking about the first steps towards GDPR compliance. If there are issues here, please do, in hearing me, please do use the chat function to let me know. You will all have noticed that you're on mute. In theory, this is now working properly, but life suggests sometimes otherwise. I'm going to be talking about GDPR, about its context, about the steps that you need to take towards compliance. If you are just tackling your GDPR journey right now, you'll probably be saying to yourself, the gap between now and the 25th of May is not very long. What is it we've got to do to get ourselves ready? I'm hoping I'll cover that a bit for you. My own background is in data protection and privacy for the last 20 odd years. The book I wrote about implementing an information security management system, originally in the late 1990s, is now in its 6th edition, and in a practical sense has given rise to IT governance, which through its newly set up holding company floated on AIM just over a month ago. So as a business, we deal very substantially around data protection, compliance, cybersecurity, penetration testing, and so on. We have service delivery in the form of consultancy, technical security, penetration testing, training, qualifications, software, tools, books, the whole range of everything that an organization might need if they're to tackle GDPR effectively. I'm going to be talking briefly about the regulatory landscape. I'm going to try and make up a little bit of the time that we've lost. We'll look at the principles of the GDPR, issues around breach notification and how that drives the behaviors which one needs to put in place, data subject rights, changes around consent, liabilities for data processors and the role of the data protection officer. We'll touch on international transfers and how pan-European consistency is to be achieved. The difference between directives and regulations is an important aspect of understanding how GDPR is going to work. A directive is a European Commission instruction to member state governments to pass law which meets a minimum set of standards, but which they can do in a way that suits their own environment and which can be adapted or amended to suit their own requirements in addition to the basic set out in the directive. And the current in the UK Data Protection Act is based on the European Data Protection Directive of 1995. A regulation on the point it comes into effect as written across all member states of the European Union, so it doesn't require implementing legislation. The GDPR, as the title suggests, is a regulation and therefore it comes into effect in all member states. It does not require the enabling legislation at all, although in the United Kingdom the government is busy putting through a data protection bill which will ensure that GDPR survives Brexit and which also puts into place the various derogations the UK government wants to take advantage of. So the benefit from the perspective of data subjects for regulation is that it means their rights are exactly the same in all 28 member states. The same benefit applies on the other side of the relationship to organizations trading in more than one state, because it means that the requirements are exactly the same in all 28 member states, and even means that you can have a single supervisory regulator with whom you do your business for all of the states within which you're trading. So the model for GDPR compliance after the 25th of May looks a bit like this. Data subjects, that's us. We have rights, and we have a right to, we own our own personal information, so we have rights in relation to that information. In principle, those rights are that we're entitled to know what's being done with it, we're entitled to being done properly and securely, and for the systems within which the data is being processed to be secure. Our data can get into the hand of a data controller, which is typically an entity, an organization, either directly from us or through a third party. So purchasing mailing lists, collecting data from third party sites, all of those continue to be legal, but there are very specific things you have to do in any instance where you've acquired data, whether directly or indirectly, about a personal, about a data subject. And we'll touch on that when we look at privacy notices. A data controller is the entity that determines the means and purposes of processing data, and this is to be thought about at a process level rather than organization level. And any individual organization can be simultaneously both a controller and a processor. You can be a controller, for instance, in relation to your own employee data, and you could be a processor in relation to data that's provided to you by a customer. If you outsource any part of your data processing to a third party, that third party is called a data processor. And under GDPR, there has to be a clear contract between controllers and processors. Processors can only process data if they have a contract from a controller. The absence of a contract, that will in effect mean that the organization is a controller and will have to meet the obligations of being a controller. So an early area for any compliance program is making sure that in all of your relationships with customers and suppliers, you know whether you are a controller or a processor. GDPR also deals with the export of data to third countries, particularly outside the European Economic Area. It doesn't go much further than the Data Protection Act did, but it certainly brings with it a different set of fines. Sitting across the top of what every organization, every member state does is the European is the supervisory authority, which in the case of the United Kingdom will be the Information Commissioner's Office, and they're required by law to supervise the GDPR to make sure it's properly applied, to enforce it, to assess compliance, provide guidance, leadership, and the whole range of powers that they can deploy. They're also entitled to expect member state governments to give them adequate budgets to enable them to do their job. So as you see, it's sitting at the heart of activity as a data controller, and the data controller is accountable for every single aspect of the processing which it causes to be done. The European Data Protection Board exists to make sure that the 28 member state supervisory authorities interpret the law in a way that is consistent, in other words, to ensure that there is in fact a level playing field across the whole of the European Union. So natural persons are the subject of GDPR. Living persons have rights, as I said, around having their data protected and the processing of that data protected, as well as the free movement of that data. And within scope of GDPR, therefore, is any personal data, and personal data is very broadly defined as anything that can identify a natural person that is intended to be or is part of a filing system or is processed by automated means. So a pile of business cards in the corner is not a filing system. That pile of business cards will be outside the scope of GDPR, but as soon as you put the business cards into a Rolodex, you put the data into a CRM system, that data is now part of a filing system, or it's being processed by automated means, or both. And in that case, it becomes subject to the scope of GDPR. And GDPR, when it's looking at data, though, is concerned with the processors of data, controllers and processors. So the focus is on organizations that might be collecting or processing data. And within the scope is any organization based inside the European Union processing the data of subjects, irrespective of where in the world they might live, and organizations outside the European Union providing services into it, whether paid or unpaid, and they too are expected to comply with GDPR. So in a sense, GDPR is the first global data protection regulation. There are many organizations around the world providing services into the European Union. And one of the big differences between GDPR and the Data Protection Directive is the mechanism by which the regulation is enforced. Supervisory authorities are given the power to impose fines up to, for a wide range of breaches, up to 10 million euros or 2% of last year's global turnover, or for a small range of breaches, but in the core areas of GDPR, which is around the 6 data processing principles, the rights of data subjects, and the transborder data processing provisions. In those areas, fines can go up to 20 million euros or 4% of global turnover. Now, supervisory authority can't just automatically impose a fine. Fines have to be both dissuasive and proportionate. Small organizations would expect to get smaller fines than large organizations, and the fine has to be proportionate and appropriate to the offense. Taking account of the extent of negligence and taking account of the technical and organizational measures the organization put in place to prevent the breach happening in the first place. So one of the things to be thinking about now as your first steps towards GDPR compliance, once you've thought about controller-processor relationships, is what steps can you be taking or should you be taking to protect personal information from breaches? Because if you're not breached, you've got your first step towards avoiding a fine. A personal data breach under GDPR is very clearly defined as basically any compromise of the confidentiality, integrity, or availability of personal data, whether accidental or unlawful. And a data processor, remember that's a third party to whom processing has been outsourced, is obliged both by law and under its contract to report a data breach to the controller with whom it's contracted, and to do so within 72 hours of first becoming aware of it. And the controller is obliged to report data breaches to the Information Commission of the Supervisory Authority, again within 72 hours of first becoming aware of it, where there is a risk to the rights and freedoms of data subjects. If there is no risk, then there is no need to report the breach. Of course, you still need to go through the process of identifying there was a breach and having a formal method for determining there is no risk, and then you cannot report it. If there is a high risk to the rights and freedoms of data subjects, then you not only have to tell the ICO, you have to tell the data subjects themselves. One of the basic ways that you can ensure that you don't have a breach is to ensure the data is encrypted. So both in transit and at rest, if data is encrypted and there's a breach, you've got a strong argument that there has been no risk. I would suggest that if it takes you longer than 72 hours to identify there's been a breach, you've already got a problem. You're probably negligent if you can't work out whether you've been breached or not. And you've also got to recognize that 72 hours is calendar hours, not business hours. So if you have a breach on a Friday morning, you're reporting it by Monday. And that means you need to be capable of handling a breach across a weekend. Most hackers look at Fridays as being good days to be making a breach. GDPR comes into force on the 25th of May. That's the end of a 2-year transition period, which started on the 24th of May 2016. So it will be applied in its entirety in all 28 member states. And there are differing levels of preparation in all member states. We're not expecting there to be a raft of enforcement actions on the 26th of May. But we do expect that from the 26th of May, data subjects will be exercising their new rights. And the rights of data subjects, along with the data processing principles and transporter data processing requirements, are core. Data subjects' rights are around the rights to be informed as to what you're going to do with their data at a granular level, the right of access to the data to confirm that you're only doing what you said you would be doing, the right to rectification if you've got data wrong or it's in error and to have it corrected, the right under certain circumstances to erasure, the right to be forgotten, not an absolute right, can be exercised in certain circumstances and can't be exercised effectively where the controller has an overriding statutory obligation or lawful basis to continue processing the data. The right to restrict data, restrict processing of data while an objection, for instance, is being considered, and the right to object to data which is being processed perhaps for reasons other than consent. The right to data portability, again, not an absolute right. This applies only to data which is in automated form provided, subject to either consent or subject to a contract by the data subject. And then finally, data subjects have got the right to be informed of automated decision-making, including profiling, as well as the consequences of that. Where consent is the lawful basis of processing, the data subject has the right to withdraw consent at any time, and they've always got the right to lodge a complaint with the supervisory authority if they believe that there's something specific that you are doing which is a transgression of one of their rights. The organization ensures that it protects data subject rights essentially by applying the 6 data processing principles, which are expanded on the 8 that were in the Data Protection Act. 2 of them, the principle about data subject rights and the principles around transport and processing, have been removed from the principles, and they're now included as single chapters or as major chapters inside GDPR, leaving 6 very specific principles around processing of personal data. Must be lawful, fair, and transparent. That means there must be a legal reason, and consent is not always the legal reason, might be the last reason you select. Must be fair and done transparently. Must be collected for specified, explicit, and legitimate purposes. That means you can't say we're collecting the data for reasons that we will think of later on, and if you're going to download this document, then you consent automatically to all of the things we might want to do, because that's not transparent, it's not explicit, it's not specified. You would fail on those specific, and it's not lawful. You'd fail on at least the first 2 principles, which means that if there is going to be a fine, it's likely to be under the higher tariff. Processing must be, the data you gather must be adequate, relevant, and limited to the purpose for which it was collected in the first place, kept up to date, retained only for as long as necessary. And so if you're collecting data, for instance, for the purposes of meeting your statutory accounting obligations, you're going to retain it only for as long as the accounting obligations require. If you're retaining it in order to deal with the possibility of a lawsuit, you retain it only for as long as the period set by the statute of limitations. So each type of data is likely to have its own retention period. And finally, the 6th principle is that data must be processed in a manner that will maintain security. Sitting across all 6 of the principles is the idea of accountability. It's expressly identified in GDPR, and the ICO, in a speech back in January last year, said that the GDPR creates an onus on organizations to understand that protecting personal data is not just about ticking boxes, it's about building a framework that ensures privacy management, data protection pervades the way the organization operates. Yes, of course, that's a big change to the culture of an organization, but for those organizations that understand that it's about governance, proportionate governance measures, part of the should be part of the overall systems approach, those are the organizations who've understood properly what their role is as accountable processors. And applying that sense of accountability means that organizations need to build GDPR compliance into the board agenda, have an accountable director who, in much the same way as you might address health and safety, is accountable for ensuring that the organization is addressing its data protection obligations properly. Have a corporate risk register which identifies not just risk to the organization, but also risk to the rights and freedoms of data subjects. You might need a data protection officer. I'll come back to the specific circumstances under which a DPO is mandated. Even if one is not mandated, you might decide that you need a GDPR compliance officer of some description, and then you need to build a privacy compliance framework, which is a combination of what's called a personal information management system, a PIMS, which is all the documentation that ensures that you're processing data in line with the law, and an information security management system, or ISMS, which is the way in which you manage information security in the organization, and which is likely to include protection of more than just personal data. You also have to have records of processing that set out clearly what you're doing. The requirement to pay an annual fee to the Information Commissioner will continue. There is a new fee regime which comes into place after the 25th of May. You'll need to be able to respond to cyber incidents and report data breaches. And in thinking about security, part of demonstrating accountability will be putting in place security measures which demonstrate that you've relied on more than just your own hope that you've got it right. So external certifications to standards like Cyber Essentials and ISO 27001 become obvious ways in which, as an organization, you can demonstrate that you've taken appropriate steps to satisfy yourself that security is adequate. In due course, we expect the emergence of more certifications and data seals, specifically sponsored by supervisory authorities, but those are few and far between at the moment. So one has to work right now in the context of all the existing certification standards, bodies and models which have existed and will go on existing. GDPR is looking for organizations to embed data protection by design and by default. That means things like data flow audits, identifying how data is collected, what happens to it, how it's processed, and in some particular instances doing data protection impact assessments. These are mandatory for a specific set of organizations, and also mandatory where you're changing a process in such a way that it's likely to create a higher risk to the rights and freedoms of data subjects. So accountability is that collection of activities and framework components. Returning now to lawfulness. We've traditionally in the UK processed data on the basis of consent. Now, consent has a very high bar, which I'll talk slightly more about shortly, but such a high bar that in reality you have to look at the other options as well. And the other options to consent include processing to protect the vital interests of the data subject, processing in order to meet the requirements of a contract you have with the data subject, processing in relation to the legitimate interests of a controller. So tracking performance of a data subject on the network and employee for the purposes of ensuring data security is a legitimate interest. You do not need to get consent for that. And in fact, where you have a non-consent legitimate base or lawful basis, you don't also need consent. And practically speaking, what we see is that it makes sense to look at all of the alternatives and see if one of those will meet the requirements, will set out why it is you're processing the data before you think about consent. Remember that controllers have clearly identified obligations. It starts with ensuring that there is a proper lawful basis for processing the data, and then for ensuring that processors with whom you contract are processing it in a way that enables you to demonstrate you are performing against that lawful basis. Consent, as I said, has a very high bar. First of all, it has to be clear and affirmative. So you can't have consent by default. You can't have untick this box if you don't wish to receive information from us. It must be tick this box if you want to receive information. And it must be a consent given on the basis of transparent, clear, and complete information, not inadequate information. So basically, if somebody reads what you give them or listens to what you tell them about what you're going to do with their data, they shouldn't really be surprised when you do it. When they are surprised, that's probably a clue that you're doing more than you were getting consent to do. Where you rely on consent, it can be withdrawn at any time. You have to make it easy for the data subject to do that. And you also have to recognize that consent automatically triggers the right to erasure, and it triggers the right to data portability. If a person's under 16 and after the data protection bill has passed, assuming it does, in the United Kingdom as written, under 13, a child cannot give consent to the processing of their own data. That means that a responsible adult has to give consent. This is only in relation to information society services. So for instance, in relation to social media, an adult has to give consent for their child's data to be processed. That means that if you're operating in that sphere and children are likely to want to use the service, you need to have a mechanism for ensuring that you can establish the person giving consent is genuinely of an age to do so. Special categories of data, what used to be called sensitive data, deal with race, ethnic origin, political beliefs, health, biometrics, and so on. It's prohibited from processing any of that data unless you can identify a specific exception to the prohibition. So special categories of data, you first of all have to have a lawful basis for doing so. We looked at that, what's called an Article 6 lawful basis. Needs to be, if there's a child involved, you need to deal with the age of consent issue, and then you need to have an exception, which include explicit consent, or maybe processing in terms of the vital interests of the data subject, or because it's an essential essential piece of processing in relation to a contract between you and the data subject. But Article 9 sets out the specific exceptions, and for every element of special category of data, you need to be able to identify the exception that enables you to process it. All communications must be transparent. The GDPR requires transparency. Articles 12 through 18 talk about all of the aspects of how you do that, and also change the basis on which data subject access requests work. You used to have 40 days to respond. Under GDPR, it will be 1 month from the date of the request. Yes, you need to satisfy yourself that the data subject is whom they say they are, and they're entitled to get the data they're asking for. But you've got you've got a 1 month window within which to respond. You need to be completely clear with data subjects about how they can exercise their various rights. The requirement on you is to facilitate the exercise of data subject rights. And all of that is about building data protection by default and by design into the way the organization operates. I've talked briefly about data flow audits and about data protection impact assessments. They're mandatory where there's likely to be a high risk to the rights and freedoms of data subjects. And data audits should be an ongoing part of what an organization does, not simply part of your initial compliance project where you make sure you know what data you've got, but an ongoing activity to make sure you continue to be aware of how data is being processed. Significant elements of GDPR do come down to security, making sure that personal data is actually secure. And the requirement is that data is processed under the sixth principle in a way that protects it against loss, whether accidental or unauthorized. And there is also in section 32, article 32 of GDPR, a general requirement for data controllers and processors to put in place a security management system which is appropriate to the risk that there is to the data that's being processed to ensure that it's properly protected. And that gives rise to thinking about management systems like Cyber Essentials, to penetration testing, to evaluating the effectiveness of security, to security audits, all of those, the kind of measures that should become part of how as an organization you go about ensuring that you are meeting the requirements to ensure security of processing. And security of processing, as I said, tied to the way in which you implement the privacy principles, the ISMS and PIMs, and the way you deal with governance creates your privacy compliance framework. I've talked about data protection officers. Let me circle back round. An organization processing substantial volumes of data where that special categories of data or its automated processing or its public authority has to have a data protection officer. That's mandated. It's a protected position. That means the DPO can't be terminated because you don't like her advice. They can obviously be terminated for normal employment reasons, but it's a protected position. And it's also a position which can't be held by somebody who will face a conflict because they have a role in addition, which involves determining the means and purposes of processing. So heads of IT typically can't be data protection officers. Heads of HR can't typically be data protection officers. It needs to be somebody who is able to have direct access to the board, who's independent of processing, and who can give independent advice, as well as dealing with things like potentially data subject access requests and the interface with the information commissioner. Outside of the mandatory DPO, as I said, somebody to have responsibility for GDPR is a good idea. Staff awareness training will become essential. You have people processing data at multiple levels inside the organization. Everybody needs to be aware of the issues around how that's dealt with. Of course, certifications are identified in GDPR as a mechanism by which organizations can demonstrate they've made best efforts to comply with GDPR. And GDPR says that international standards, recognized national management systems, recognized national technical standards are all appropriate ways for organizations to demonstrate they've made appropriate steps to meet the requirements of GDPR. It's not possible for any organization to certify compliance with GDPR in any meaningful sense because GDPR is a law and compliance with the law is ultimately determined by a law court. And there are many phrases and terms and requirements in GDPR which are insufficiently clear that one can't expect there to be a series of court cases over exactly what the requirement is. So a certification, while a way of demonstrating good intent, demonstrating accountability, doesn't necessarily absolve the organization of actual compliance. GDPR also deals with the transfers of personal data and says that personal data in effect can't be processed outside the European Economic Area unless the country to which it's going has been assessed by the EC as having an adequate data protection environment. And other than the 28 member states, there are about 10 or 11 countries around the world which have met that adequacy standard. New Zealand is one, Australia is not, the United States is definitely not, the Isles of Jersey and so on definitely are, Canada definitely is. If it's adequate, if there's adequacy finding, you can transfer data to organizations in that country very straightforwardly. If you want to transfer data to an organization in the United States, that's possible if the organization is registered under something called the EU-US Privacy Shield, which is a mechanism by which, in effect, a US organization can claim that it's operating within a regime that is adequate. Or alternatively, you can do it through some combination of binding corporate rules inside an international organization or standard contract clauses set up between organizations dealing with specific processing of data. All in all, the requirement is that controllers have to ensure that data is processed securely if it's moved outside the European Union. And if you're dealing with a processor who is financially insecure or who breaks the law, you have to work on the basis the Information Commission or the Supervisory Authority will concentrate their enforcement action on the controller, not on the processor, because it's the controller that has the obligation to ensure compliance. And as we're coming in towards the last handful of slides, just if you haven't already realized, please do, if you have questions, use the question function in live in GoToWebinar here, type a question in there, and in what few minutes we have left, I'll try and pick up the most interesting questions, and I'll share them and share answers with everybody. So independent supervisory authorities, of which the ICO is the UK's version, are able to monitor and enforce and promote awareness of the GDPR. They can investigate, correct, advise, and so on. And they can also act as a lead supervisory authority, as I said, so that an organization can deal with one regulator for all of its pan-European activity. Of course, once Britain leaves the European Union, it will be a third country. It will be outside the EU. We don't know whether the UK will be successful in getting an adequacy finding in respect of the UK, but in any case, even if it does, UK organizations will have to appoint a representative after Brexit inside the European Union, because that's what the GDPR says. And there is also very little certainty that the ICO will be able to act as a lead supervisory authority across the whole of the European Union, because GDPR is explicit that lead supervisory authorities have to be the supervisory authority of a member state. The European Data Protection Board sits across all of the member states to ensure consistency and interpretation. It can deal with any questions arising. It's not a super regulator. Its job is to ensure consistency of interpretation, and it will be created out of what's called Working Party 29, which is the group drawn from across the European Union, which has been responsible for creating GDPR and for issuing the detailed guidance which has been published over the course of the last nearly 2 years. So in sum, the Information Commissioner said, yes, she recognizes that accountability is going to have an upfront investment in privacy fundamentals, but that's a good thing to be doing. It should give an organization a competitive edge. It should mean there's a real opportunity for organizations to position themselves on the basis of how well they look after personal data. But she said if you don't do that, that's fine, because of course we've got these huge regulatory powers. We've demonstrated in the past that we're perfectly happy to take action where people breach the law, but do bear in mind that it's not simply a breach of the law that we punish. We will investigate, and if we find there is a deeper issue, the fines will be based on the deeper issue, the real practices, rather than the minor issue which has led to us carrying out the investigation. So 9 steps to GDPR compliance. If you're only just starting the journey now, you're probably not going to make it by the 25th of May, but that doesn't change the fact that you should get started. You should be able to demonstrate that you've made as much progress as you can. Put a governance framework in place, make sure the board's aware, have a risk register, have it in the corporate board agenda, have an accountable director to decide whether you're going to have a data protection officer or some senior data protection GDPR compliance role in place. Do a data inventory, identify what personal data you've got inside the organization, identify unlawfully held data and change its status. Employees, for instance, if you're processing their data on the basis of consent, that will be invalid under GDPR. You need to issue new employment contracts, which puts the basis of processing on a combination of statutory obligation, legitimate interests, and fulfillment of a contract. So do a data inventory, work out the relationships between yourself and suppliers where you've got control of processor relationships, and then do the detailed data flow audit that identifies how data is actually being dealt with. That enables you to do the detailed compliance gap analysis and to publish out of that privacy notices that set out what it is that you're doing, and to flow through into data subject access request processes, which enable you, when a data subject says, what are you doing with my data, to very quickly identify what it is and to be able to answer that. As your data protection impact assessment and security analysis steps up, you'll have a much deeper sense of what you need to do to improve security, then drive remediation, identify what you need to do, remediate, build a privacy compliance framework, look at the Cyber Essentials or at ISO 27001 as mechanisms to demonstrate that you've taken appropriate steps. Put in place an incident response process, test how you're going to deal with data breaches. You've remember got 72 hours to respond. You don't want to be working out on the day how you're going to respond, so prepare in advance, and then put in place an ongoing process of monitoring and continually improving. GDPR is a journey, not a destination. You're unlikely to be compliant by the 25th of May. You're unlikely ever to be perfectly compliant, but embedding data protection by design and by default is certainly a program that will take multiple years to achieve. There's a lot of skills to develop inside the organization, a lot of processes which need to be reviewed. There's a number of ways in which we can help you tackle stuff as an organization. We publish pocket guides and implementation manuals. We have documentation toolkits, which you can buy off any of our websites. There's a gap assessment tool, which if you've got an understanding of how GDPR works, is a useful way of identifying what the gaps are and what you need to do. There is a series of training courses available. There is foundation, practitioner, and data protection impact assessment training courses, both online and in the classroom and in a distance learning format. And our consultants can deliver consultancy support in a number of different ways, from gap analysis through data flow audits, helping with implementation of management systems, information security, cyber health checks, and so on. So pretty well anything that you might need. And for a number of our clients, the first step has simply been to call us and arrange to have a consultant come and do a gap analysis to identify what it is that you need to be tackling. But anyway, however you want to tackle it, there is a range of ways that you can do so. We'll continue delivering webinars up to the 25th of May and beyond it, dealing with particular issues and specific matters. So do feel free to get them. Mostly our webinars start on time. Mostly we don't have connectivity issues, but do feel free to come on any future webinars. So as I said, if you have questions arising from this webinar, please do use the question functionality in GoToWebinar, and I will go through as many of the questions as I can and answer them. So many of you noticing that we've had a crash, for which again, multiple apologies. And does paperwork that has not been properly disposed of fall under GDPR? For example, something in a paper bin that was never part of a filing system but can still identify a living person. Well, I guess technically not. If it's in a waste paper bin, it was never meant to be part of a filing system. It's not processed on an automated basis. Technically, I think you could say it's outside of the scope of GDPR, but I think any lawyer who was feeling particularly difficult would want to know how it got into the waste paper bin. Has it been intended that it should be collected, or was it the output from automated processing? So I would suggest that if you're going to be throwing personal data away, you do so securely, you shred it in some format. Is a person's name only personal data? Your name is personal data. Anything that will identify you is personal data. So your date of birth is probably personal data, although obviously it's shared with many millions of other people. But a combination of date of birth, mother's maiden name, and perhaps your address. That might enable someone to identify you precisely. So whatever can identify you includes biometric, genetic data, it includes IP addresses. That's all personal data. How best can you find out retention periods in various EU countries? It's a long slog. We're busy trying to finish off a program of doing that ourselves, which we hope to be able to publish. But in practical terms, it means you've got to start with each of the different authorities, each of the different types of data you're processing, and then go and look in, talk to your lawyers and identify what the period is. As I said, I hope we'll be able to publish something on that relatively soon. Yes, there will be a copy of the webinar made available to everybody. What is the guidance around existing personal data? The guidance around existing personal data is that it needs to be compliant with GDPR from the 25th of May. The law doesn't say that you have to comply prior to the 25th of May, it just says from the 25th of May. So you might be processing data legally today, which will be processing illegally on the 25th of May. So you should be looking at all the existing data you've got and looking for a lawful basis to go on processing it. And with marketing databases, it's not likely to be necessary for you to go back and seek consent to people from whom you have been, to whom you've been sending information for a long period of time. It may be that you can apply the legitimate interest test and demonstrate that you have an ongoing legitimate interest in sending information to people who have been happy to receive it from you. As long as you tell them that that's the basis, and you tell them how they can object to it, and you document that you've done the legitimate interests test. When dealing with sub-processes in the European Union, do we still need contracts? Yes. Can these be in the form of online terms and conditions of service rather than individualized and signed documents? I wish you luck if you don't have an individualized and signed document, because your struggle will be to demonstrate that the processor understood what it was you wanted them to do. And in particular, you will want them to report data breaches, which means you'll want them to understand who to report it to. So your contract will want to set that out clearly, and you will not want a situation where somebody is able to argue in court that they did not know what they were meant to be doing, not least because that could create a situation where it comes back on you as the controller as having failed to properly contract with the processor. On the subject of data portability, as a data controller, does GDPR mean that I am able to leave SaaS CRMs with greater ease? As a data controller, as an organization, you should be able to, depending on the contract you have with your supplier, move data, but the right to data portability is not a corporate right, and it's individual right. So you, the data controller, if you've got a lot of staff information or customer information on a SaaS system, you can't automatically rely on data portability, the right to data portability, to move it to another organization. Your individual customers can, but you can't as an organization, as I say, because it's a personal right, not a corporate right. Recordings, yes. Must employee data reside in EU? No, it doesn't have to reside in the EU. If you're going to move data out of the European Union, then it can go to anywhere as long as one of the tests for lawfulness is met. And the tests start with an adequacy finding. They include standard contract clauses or binding corporate rules, but you have to be able to demonstrate that there is a proper legal grounds on which you're moving the data out of the European Union. Lawful bases of processing data. One lawful basis of processing data is in order to meet a statutory obligation. So for instance, you, in selling a product to a consumer, you're going to collect their name and address, and you're going to keep records of the invoice because you've charged them VAT, and you have to keep VAT records for, let's say, 6 years. So your purpose of processing the name and address in relation to VAT will be in order to meet a statutory obligation to report VAT. That's lawful. You don't need consent to do that. Where data is held in the cloud, who is responsible should there be a data breach on any of these systems? If you're the controller and you have stored data in the cloud, you're obviously ultimately responsible. So if you're storing in the cloud, you want to make sure that the processor with whom you're storing it has adequate security and a mechanism for ensuring you, if there's been a breach, within that 72 hours. Can you charge for data requests? No. Under GDPR, you can't. You've got a month to respond, and you can't make a charge unless the requirement, the data being requested has is onerous in terms of putting together the data, in which case the obligation is on you to prove that you're entitled to make a charge, and then no more than the actual cost. B2B, don't think of B2B as giving you any difference than B2C. Where GDPR is concerned, it's interested only in the rights of data subjects, and my business email address identifies me just as much as my private email address does. And so in a B2B environment, the contact details for individuals working at customers and suppliers is just as much personal data as is a consumer's personal data. An email to joeblog@businessname is therefore, yes, personal data. You need to, yes, tell people whose data you're processing, the lawful basis on which you want to continue processing it, if you're to continue processing it. Otherwise, obviously, if you don't have a lawful basis, technically you should stop. And I will just pick up a couple more questions because we will run out of time. Will travel agents have to consent every time a client books a ticket? I absolutely don't think so. If a client is booking a ticket, you need to collect their data in order to give them the ticket. So the lawful basis for processing that information will be in order to fulfill a contract with the customer. Consent should be the last thing you think of. You should be looking at, why is it that I need this data? Once you're clear about that, go look at the list of, in Article 6, lawful basis for processing data, and select the one that seems to be most sensible. How do we go about checking the person who's asked for information is who they say they are? You've got to make those rules, but you have to put it beyond a doubt. So you might ask for identification, perhaps some combination of photo ID and address ID, but it's got to be a level of information which is adequate but not excessive. In other words, it's not going to be a barrier that you put in place to providing the information. And at the moment, there isn't any clear guidance. You've got to work out for yourself what appropriate looks like. So liability or enforceability of GDPR. Let me make this my last question. Who have no permanent established in the European Union, but who use a third-party employer of record to provide services. So if the organization outside the European Union has contracted with an organization inside the European Union, it's providing services, and there is a data breach either at the service provider, who is probably a processor but might be a controller, probably a processor, or there's a breach at the external controlling organization, then I would expect the supervisory authority to take advantage of international law to pursue the organization outside the European Union, and if it can identify a practical basis for doing so, it would simultaneously pursue the organization inside the European Union. But in truth, we don't know, and until there are some breaches and some actions by supervisory authorities, we're not really going to know how they're going to do this. The steps that we see most organizations taking is based on their recognition that the European Commission and supervisors around the European Union have had no compunction in the past about pursuing organizations outside the European Union who've broken EU law, and therefore assuming that they simply don't want the hassle of having to cope with a legal action, and so seeing getting GDPR compliant as the lesser of two evils. Ladies and gentlemen, I'm afraid we've run out of time. I'd just like to apologize again for the delay that we had starting this webinar. I'd like to thank you all for being here. We will be sending out slides over the course of the next few days. There are, as I said, repeat webinars that you can come on to, and so I'd like to thank you all for your patience. I'd like to thank you for being here. Wish you luck on your GDPR journeys, and of course, if we can help you, please do come onto any one of our websites or call us directly, and we'll put in place a package of services that might be appropriate to help you accelerate what you're trying to achieve. Thank you for your time. Good afternoon.